How to respond to the 90-day IRS letter statutory notice of deficiency, IRS Publication 3598. Hello. If you find yourself running out of time on the 90 days filing a tax court petition, paying court fees, and representing yourself, pro se, or hiring a tax court lawyer are expensive last-choice decisions. They are costly, and the tax court, I hate to say, usually favors the government. The best solution is to manage the IRS examination, aka audit, IRS appeals, and/or IRS collections early and often to obtain the best outcome. The problem with the 90-day letter is that it is an uphill battle to change the proposed assessment amount, and the IRS may not respond to the request. If left unchallenged, the assessment will proceed to IRS collections, and collections will assume the amount is correct. If the amount in the 90-day letter is incorrect, and you have the documentation and tax authority backing your position, IRS examination, appeals, and/or collections will want to settle the case. When the average taxpayer does nothing about the 90-day letter, there may not be extra time left to arrive at a resolution with the IRS examination. Subsequently, if the taxpayer fails to timely file the tax court petition, the taxpayer's options become limited, and resolution becomes more expensive. Many cases settle in IRS appeals before the tax court hearing date. Resist going to tax court. Before going to tax court, if you petition, they'll assign it to the IRS appeals as a docketed case, and you can settle there. Try to work with the IRS, but if the 88th day comes, you must petition the tax court to preserve your rights. Petitioning in tax court is more manageable than it sounds. The tax court petition transfers a taxpayer's file to appeals from anywhere in the IRS system. The court first sends the file to IRS appeals to be worked out. Suppose you can settle with IRS before the petition files. Money spent on the fees for filing the petition and the additional correspondence required for dealing with the IRS attorneys is no longer necessary. It is much easier to negotiate the total amount of an entire tax liability established in IRS appeals. At this point, the IRS appeals officer can deal directly with the situation rather than spend time on the phone with IRS examination, IRS customer services, and IRS collections. Anyone, an enrolled agent, accountant, or even a person with no professional training, can assist other taxpayers in tax court, presuming the taxpayer on the court petition is willing. Beforehand, go to a tax court and watch a proceeding. This is a valuable experience to learn how the court operates. Tax court proceedings differ from federal court, but timeliness, preparation, and etiquette provide the best odds for success. The tax rulings are relatively predictable. Many observed tax court judges offer more room for parties to argue points. Filing a tax court petition is an excellent tool for buying more time to prepare the necessary documents to prove the assessment should not occur. You will likely have 6 months after you file the petition before you even hear from an IRS appeals agent. Keep in mind that as long as you have not signed and waived your disputed rights with a closing agreement, IRS Form 906, a compromise agreement or an appeals agreement, IRS Form 870 AD, with the IRS, you do not have to go to tax court. So before you sign anything, consult with someone you trust. Thank you for watching, and good luck.